Good morning. Today we are going to analyze one problem question on tort law, occupiers liability in negligence. The video content has been made available for informational and educational purpose only. Kindly go through this slide completely. Let's kickstart with the problem question. Hibernia School has sold its disused sports hall to a developer tower construction. We'll call it as TC, who plan to refurbish it as a concert venue. Although TC had not yet taken possession of the hall, local youths had been entering the building to climb on the unstable climbing frame, and so TC put a barrier around the hall. Dave, a teenage boy, got through the barrier and attempted to secure the climbing frame's ground safety anchors and was injured when the frame fell on him. The head teacher had just shown Anna and her 6-year-old son, Jose, around the school. As Anna responded to an urgent work email, Jose wandered off and skewed to the banister of a staircase where he fell and sustained a serious injury. Ron, a 16-year-old student, went to play table tennis in the games room. He suffered an eye injury when he was hit in the eye by a tennis ball. As Kai, the school electrician, was replacing the bulb on the light fitting, he accidentally touched an exposed wire and suffered an electrical shock. We have to advise the parties. The scenario presented involved various instances of the potential occupier's liability under both the Occupier Liability Act 1957 and Occupiers Liability Act 1984, as well as some consideration of general negligence. Let's start with the first one, the Dave's injury on tower construction property. This is the Occupiers Liability Act 1984. Since Dave was trespassing when he bypassed the barrier and climbed on the unstable frame, the 1984 Act, which applies to non-visitors, is relevant here. Dave's case primarily engaged the Occupiers Liability Act 1984, which imposed a duty of care on the occupiers towards the trespassers. Tower construction could be considered the occupier since they have taken steps to secure the premises, even though they have they haven't yet physically occupied it. In wheat versus Lacan, the control over the premises is essential to establish the liability. Thus, TC act of erecting barriers suggests that they assumed some responsibility over the site's safety. Under Section 13 of 1984 Act, an occupier owes a duty to a trespasser if they are aware of the danger, they know trespassers may encounter it, and they can reasonably offer protection against it. The frame's instability is a known danger, as a TC erected barriers. However, this barrier proved insufficient to prevent access, and TC could reasonably have foreseen that you, the youth, might bypass it. The president in Jolie versus Sutton case, where the occupier was held liable for the injuries resulting from the children's playing on a abandoned property, supports the view that TC may be liable if it failed to take the adequate measures to secure a known hazard. In other words, a TC, though not in possession, would be considered an occupier under Harris versus Birkenhead Corporation in 1976 case, where the control rather than the physical possession determined the occupier's liability. A TC was aware of the local youths entering the hall and erected a barrier indicating the knowledge of the risk and the likelihood of the trespasses. However, they might argue that they took reasonable steps to deter access by installing a barrier, possibly fulfilling their duty under the 1984 Act. In Jolly vs. Sutton LBC, the court held that the occupiers are liable if the injury to the children is forcible, even if the precise manner of injury is not. However, Dave's injury from an unstable frame is a forcible risk where children enter an unsafe building. TC could still be liable since the barrier alone might be deemed insufficient. To conclude, TC may be liable under the 1984 Act for failing to ensure the claiming frame as securely inaccessible considering the predictability of the trespassing youth. In other words, the TC may be liable for the Dave's injury if the barrier is found insufficient under the 1984 Act, considering the forcibility and the duty to protect the trespassers from the harm in this context. Let's move on to the issue two, where the Joes fall in the staircase at the school. Joe's status as a young, a lawful visitor to the school brings this case under the Occupiers Liability Act 1957, which obliged occupier to keep the premises safe for the lawful visitors. Under Section 2 of this Act sets the common duty of care standard, requiring the occupier to make the premises reasonably safe for the visitors, especially the children who may not recognize the potential hazard as adult would. Joe's being a lawful visitor, a school tour with Anna is owed a duty under the 1957 Act, which imposes an obligation on the occupiers to ensure lawful visitors are reasonably safe for the purpose of the visit. In other words, the children are given the special consideration under 1957 Act. In Glasgow Corporation versus Taylor in 1922, the court highlighted that occupier must anticipate the natural curiosity of the children, especially when the hazard exists on the premises. The staircase with the gaps is the banister presents a forcible danger to the children. In other words, the Glasgow Corporation versus Taylor, it was held that the occupier must consider children's lesser ability to identify the risk and protect them accordingly. Similarly, in Fifth versus Roster highlighted that responsibility could partially rest on the parents. However, this case differed because Anna was preoccupied, not willingfully neglectful. Given these factors, the school may bear the responsibility for failing to secure or restrict the child access to areas such as staircase with wide gaps. In other words, the Phipps versus Roaster Corporation also held that the occupier should expect the children to be supervised, but since Joes wandered off while Anna was distracted, liability may depend on whether the risk posed by the staircase was sufficiently safeguarded to prevent such an accident. In Bonnie Leisure versus Madsden in 2009 case, the court ruled in favor of the occupier, noting that certain risks like ponds are apparent to the responsible parents. However, unlike an open pond, a gap in a staircase railing may not be apparent, making Hibernia potentially liable. To conclude, a school might be liable under the 1957 Act for not ensuring the safe premises for the young visitor who predictably might stray from adult supervision. In other words, Hibernia School could be liable under the 1957 Act for not safeguarding against the forcible hazard, particularly as the risk might not have been immediately apparent to Anna. Let's move on to the third case, Ron's eye injury in the games room. Occupiers Liability Act 1957. Ron, being a lawful student using the facilities, is also protected under the 1957 Act. However, the injuries sustained during the ordinary activities may not automatically render the occupier liable. Simkis versus Ronda in 1983 case emphasized that occupiers need not guarantee absolute safety, only reasonable safety. Playing the table tennis in a games room involves inherent risk, and a minor injury from the game activity might be considered part of the activity's accepted risk. In Rolls versus Nathan in 1963 also supports that occupiers are not liable if a visitor fails to protect themselves from the obvious risk, such as those inherent to a sporting activity. In other words, the Rowan's eye injury from the table tennis ball incident does not directly arise from the premises stage, but rather from the activity on it. Under the general negligence principles, occupiers may still owe a duty to the visitor to prevent injuries arising from the activities on their premises. This can also relate to the Occupiers Liability Act 1957 under the activity duty, which holds the occupiers accountable for injuries from forcible and preventable activities on the premises. In Simcase versus Ronda case, it was argued that forcibility of injury plays a crucial role in determining the liability. Here, the school could argue that playing the tennis table normally does not pose a significant risk, but providing a protective measures like goggles might have reduced the likelihood of the injury. Whereas in the Tomlinson versus Congleton case in 2003 is also pertinent as it held that occupiers are not liable for injuries when individuals engage in inherently risky behaviors. Here, playing the tennis with potential ball injuries may fall into the category of accepted risk. Hence, conclude liability may be limited to the low risk nature of the activity, but the school might still owe a duty under the general principle of care expected in preventing the forcible injuries during the activities. Hence, it is unlikely to be liable under the 1957 Act of Roan's injury as it occurred during a routine activity within the inherent risk. Let's move on to the final issue, chaos electric shock injury. Chaos injury involves workplace safety, particularly related to employees' liability for maintaining a safe work environment. This aspect is addressed by Health and Safety at Work Act 1974, which requires employers to ensure all reasonably practicable measures are taken for employees' safety. The school could be liable for failing to provide a safe work environment if K was not provided with the proper tools or the safety measures to avoid electric shock. Rolls versus Nathan established that an occupier is not liable for the risk arising from specialist failure to guard against the job's related dangers. They are trained, they are trained to handle, but only if they have been adequately warned. Thus, if the school did not sufficiently warn or equip Kai, it might be liable. In other words, Kai, the school electrician, is an employee performing the maintenance and can be considered a lawful visitor with a specialized role. Under Rolls versus Nathan 1963 case, the occupiers are not liable for the harm to professionals from the risk inherent to their job, especially if the professionals should be aware of the risk. Coy's electrical shock occurred while performing his work on the light fittings. This falls under the occupational hazard, which Coy is expected to recognize and mitigate as part of his expertise. As in the Rolls versus Nathan, professionals who knowingly undertake the hazardous task assume the responsibility for the obvious risk. So it relieves the occupier's liability. Let's conclude the school could bear the responsibility for failing to ensure safety protocols and warnings, depending on whether they met the statutory safety obligations under the Health and Safety at the Work Act. So the Hibernia School is unlikely to be liable for the caused injury due to the principles and roles versus Nathan, which suggest that the professionals should manage the risk inherent to their duties. Overall conclusion, the first case, Dev case, a TC may be liable under the 1984 Act due to the forcible risk, though they may defend that the reasonable steps were taken with the barrier. The second case, Joe's case, the Hibernia may be liable under the 1957 Act for not safeguarding the staircase gap, considering the Joe's age and the forcible risk. A third item, the Roan Hibernia likely has no liability under the 1957 Act due to inherent risk of sports activity. And the final one, Koi, the Hibernia is not liable under 1957 Act as Koi assumed the responsibility for occupational risk per Rolls versus Nathan. In summary, the liability hinges on the specific duties owed under each act, the forcibility of risk, and the inherent danger associated with certain activities or occupations. Thank you.